Good morning and welcome to everyone. We're so pleased you could be here. This morning's focus will be on groundwater. Tomorrow we're going to talk about surface water. And we're going to start with the basics of groundwater law, some historical perspectives of various issues associated with groundwater law. And to do this, we've assembled what I think is one of the best panels I've ever been able to participate and moderate with. I have three very distinguished jurists who have practiced for many years. Some starting in the elementary school, like Justice Patterson, who's been doing this a long time. But I want to introduce everybody quickly. I'm going to start with my far left. I have the Honorable Craig Enoch, former Justice, Texas Supreme Court, retired now and in private practice in Austin. Justice Enoch is going to be celebrating his first grandchildren in about the next 45 to 60 days. And I understand it's twins. So he's got double the fun and double the trouble ahead of him. Justice Patterson is retired from the Court of Appeals in Austin. She still sits as a senior judge by appointment. She's currently the justice in residence at the Baylor Law School. But I've recently learned that one of her real claims to fame is that as a young Texas lawyer, newly licensed, she went to work for a large law firm in New York City, and at one point in time had the opportunity to prosecute members of the mob. So she is a power to be reckoned with, and she demonstrated that when she sat on the bench. Our third panelist this morning is the newest member of the Texas Supreme Court, the Honorable James Blacklock. And Justice Blacklock was kind enough to join us this morning to give us some perspectives on groundwater law from his new position. But prior to joining the court, he served as general counsel to Governor Abbott, and prior to that was part of the staff at the Attorney General's office, focusing on a number of things, but in particular, something that's important to many of you who are from governmental entities, open records and open meetings issues. And our three panelists this morning are going to go over some overview points, and then we'll also be able to take some questions at the end, I'm hopeful. As we get in, I want to just go through a couple of points. The slide up to that right now shows you the points the panel will cover and that we'll be discussing. We are focusing on policy, not so much issues, but the policy and the various factors that drive the policy that cause us to pass the laws and then enforce them. And this quote from Justice Pope from 1982, I think, is a critical one, because of all of the things that drive Texas water law, our weather is probably the biggest single issue. And so this is something to keep in mind, and you'll hear more about it. Texas law, as many of you are aware, is actually influenced by many things. We talk about English common law, but you have to remember that colonization from Spain, France, Mexico, all have influences on Texas law. And when you read some of the historic opinions, you'll see very detailed and well thought out histories that talk about these things, so it's important to keep in mind. Groundwater law, this is just an overview of some points you're going to hear something about this morning. But very quickly, I want to give you a quick timeline, and this shows you how our groundwater law has evolved in part in some of the key moments. 1836, of course, is the Battle of Alamo, and Texas declares its independence. 50 years, it's actually 70 years later, we have the East decision in 1904, adopting the rule of capture for groundwater. 10 years later, we have the Supreme Court adopting the rule of capture in oil and gas law, an interesting point because of the analogies that you now see the court making to oil and gas law as to be the precedent to be followed as when you look at groundwater issues. In 1917, we have the Conservation Amendment adopted. This followed a prolonged period of drought in the state, followed by some flooding. But it was the people of Texas telling the legislature, you now have the power to make all of the laws necessary related to our natural resources, and this included our water. This is not only important from the standpoint of those powers, but another issue we're going to talk about with regard to separation of powers and the relationship of the courts and the legislature when it comes to groundwater law. 1955, the Corpus Christi Pleasanton case. I've singled this case just for the point of that was made where Justice Calvert made the comment that it was the duty under the Conservation Amendment of the legislature to pass the laws and not for the courts to legislate from the bench. 1997, we have the legislature enacting Senate Bill 1, sometimes referred to as the Omnibus Water Bill. In 1998, we have Justice Enoch, almost 100 years later, writing an opinion for the majority of the court for the first time really redealing and relooking at the East case. So it's Justice Enoch's opinion in that case that started the current generation of groundwater law that we consider in many respects. 2011, you saw the legislature act again by making amendments to Chapter 36 that formally recognized in that chapter the ownership of groundwater as a private property interest. The next year in the Day case, the Supreme Court reiterated that in Justice Heck's opinion for the majority. 2013, we had the Bragg opinion because the Day case didn't really address the issue of damages when it came to groundwater takings, but the Supreme Court chose not to take it, so that left questions unanswered, which we still are looking for some resolve. And we have both the legislature and the courts to look to as we go forward there. 2015, very briefly, we have an example in the Coyote Lake case of the court adopting and analogizing oil and gas precedent to groundwater law. One of the themes, not necessarily a trend, but a theme we're going to talk about today. Earlier this year, you had a district court in Bastrop take one of the concepts from the Day case, the idea of fair share and the idea that landowners own the groundwater beneath their property, and apply it to reverse the decision by a local groundwater district to allow landowners to have standing to contest permits. It reversed the decision on a permit. That case is going up on appeal and is one to watch, so I mention it so you make sure you follow it. And most recently, the Texas Commission on Environmental Quality has granted a petition under Chapter 36 to review the actions of a groundwater district filed by a landowner asserting that the groundwater has failed either to adopt rules or enforce rules in a way that is adequate to protect this very valuable resource. And so these are some of the events that have preceded this morning's conference that we want to keep in the background. And with that, I'm going to turn this over to Justice Patterson, who will start this morning with some information about science, a very important element in your consideration of groundwater issues.
Yeah.
Oh, Justice Enoch, I'm sorry.
But let us, those standing in the back, there are seats up front if y'all want to move forward and get comfortable.
Please.
Yeah, this is not the Baptist church. You all can move forward and find some seats to come to. Ed, thank you very much for the invitation to be here, and I appreciate Professor Griffin putting this together. I have a little slide later on in acknowledgement that we were in an economics school here to talk about that, but we will. We thought we'd break this down. Justice Patterson is the justice in residence at Baylor Law School, and she was going to talk to you about the overview about policy of water, give you a description of the difference between courts making decisions in individual cases and the duty of the legislature to create policy, and give you a little bit of history of what's been, of the battles going on between the legislature and the courts as we go forward. So one of the things the courts have to pay attention to is science in the courtroom, and she's going to talk about that, but I wanted to let you know a little bit. One of the things that economists and other professionals complain about the courts and law is the only profession that when you're deciding a case going forward, you look backwards to rely on cases. And you rely on students in law school and their law review articles to guide the courts on their decisions rather than the established professionals who've been in the work for a long time. So we'll talk about the rules and science in the courtroom, and you'll get a little flavor of these are not reaching out in the future or guessing on the future, but really get established based on what things have been happening in the courts leading up to that time. Justice Patterson.
All right. Well, I too am so honored to be with this panel, and I thank you for inviting us here today. And I want to start off with a parable by the writer David Foster Wallace, who tells the story of two young fish who are swimming along a river, and they encounter an older fish swimming the other way. And the older fish says to the younger fish, "Morning, boys, how's the water?" And as the two younger fish swim on, eventually one turns to the other and he says, "What the hell is water?" So now Wallace is not really addressing water or water issues, but he's talking about the awareness and the importance of awareness in our day-to-day lives, thinking about what is real and essential in our lives, what is hidden in plain sight that escapes us because we are so absorbed in our pursuits that we fail to see the obvious. So I use this parable in law school to challenge my law students to help clients and juries and judges to see a problem with what I call new eyes, to put yourself in the place of those at the heart of the problem and to help them see the reality around them, to see the water, what they're in the middle of. This morning I use it for both purposes, to talk about real water and to talk about how often we don't understand the many, many issues involving water. Or we hold simply to the traditional concepts of water use. What the hell are our water issues? Sometimes it is too little water and drought. Justice Pope did write the story of water law in Texas is also the story of droughts. Sometimes it is flood control in river systems or hurricanes and runoff. The story of water in Texas is that it is either too little, too much, too late, or at the wrong time. But it is more. And so I have entitled my remarks to you this morning, All Water Matters. So we have short memories when it comes to water. The fact is that in Texas, we know how important those droughts have been, and we know droughts all too well. We know how the 1950s brought Texas into scientific water planning as a result of extreme droughts between 1950 and 1957. 1971 and 2010, 2011 brought us hot years and one of the driest periods that ever recorded in the state. And again this year, we were threatened with shortages and droughts starting right after the hurricane. Now, I must tell you that I wrote my remarks early on, several weeks ago. And so I was going to tell you that parenthetically, what happens is that whenever we call a water conference, it rains. And true to form, what happened last week, we had headlines in Austin talking about how, referring to last week's storms that brought historic rainfall. So I look upon water conferences as sort of a rain dance. And the ultimate rain dance is when the legislature meets, because then that gives them the excuse, right, to not have to deal with drought and water problems. So those are the ultimate rain dances. So you mark my words that when the next legislative session begins, it will rain. So I don't pretend to be the wise older fish explaining about water to other fish. I do want to share with you what I think has changed over the last few years in the area of judicial decision making, particularly in the areas that are informed by science or that should be informed by science. So there are 3 points I wish to address. First, the role of courts in decision making. Second, the role of science in the courts. And then third, I will leave you with some questions raising the nature of the water problem, or what the hell is our water problem, and can we look at it with new eyes? First, the role of courts. You will recognize the two polar views of the role of judges in dispute resolution, much less water disputes. Invariably, judges, whether they are elected or appointed, will promise not to make law. I will follow the law. I will not make the law. We've all heard that. I think the judges who reviewed the opinions I wrote when I was on the court, by and large, concluded that I was a strict law follower. But let me suggest to you that even the strictest law-following judges make law in almost every case. There are very few cases that come before judges at our level that are clearly covered by existing precedent. That's why they are on appeal. They fall into the interstices or the ambiguities of the current statutes or language of cases. So then we see the polar opposite view about judges. We see legislators in hearings when urged to follow practices of other states, regions, or heaven forbid, the federal government, who urge, let's just see what the courts have to say about it. Or we hear lawyers, right? Why don't we just settle it at the courthouse? These are the same lawyers and legislators, I think, who complain about activist judges. So am I right, Justice Enoch? And I
Always.
I won't put Justice Blacklock on this point here, but this is why I'm honored to be with you today, and I applaud the focus of the conference, which is about policy. And in honor of that focus, I looked up the definition of the word policy. Policy is generally defined as a definite course or method of action selected among alternatives and in light of given conditions to guide and determine present and future decisions. A high-level overall plan embracing the general goals and acceptable procedures, especially of a governmental body. So not to diminish the role of judges, my first point is litigation is not a policy. It is not an overall plan. It does not define definite course or of method of action selected among alternatives and in light of given conditions. It speaks to the particular dispute before the court in the form in which it has percolated through the trial court. I suggest to you that only if the legislative branch has failed to engage should the decision-making default to the courts. But even then, the courts cannot choose which issues are going to come before them to guide a definite course or method of action. They hear and they decide exactly what is in front of them, and only those issues and only those parties. It is the rare lawsuit that has the perfect parties to speak to the law in an exact manner, to address the law in a comprehensive fashion. So I want to challenge the assembled gathering that we are at a critical point in the development of water supplies in our state, as well as a point of opportunity. And I hearken back to our chronology here, beginning in 1954, 64 years almost to this very day, then Texas Governor Alan Shivers called for long-range planning for Texas relief, for drought relief in Texas, and spoke of that we had to do something more than just temporary expedients. So in Texas, we have the best of both worlds. We have policy designed by the legislature and interpreted as necessary by the courts. And the legislature has stepped up from time to time with comprehensive statutes such as SB 1 and 2 and Chapter 36 of the Water Code, among others. My second point has to do with the unique opportunity that presents itself to us at this critical time dealing with the science of water. The latest contributors to this great collaboration are the agencies of the state and federal government, and that includes the engineers and scientists who share their knowledge as resources for the legislature and also as resources for the court system. What we know today is not what we will know tomorrow. Now, I don't want to sound naive here. We all know that engineers, consultants, academics, scientists, hydrologists can also be lobbyists too, urging specific results for a client. But this is where the judicial system can play an important role. The role of the expert, the scientist, the truth teller now plays an important role, an enhanced role in the decision-making process in our courts. And we have reason for optimism about that increased role. I had the honor recently to host a national water conference of judges sponsored by the National Judicial College at Baylor Law School. I have attended the National Judicial College's Dividing the Waters conferences for many years in the western states, and I thought it would be perfect to invite them to Texas, and where better but on the Brazos River at Baylor Law School. And so it was a perfect setting for issues of water, groundwater and surface, supply of water, and the law of water to percolate. And that pun is intended, and some of you participated in that conference. Among the speakers at this national college were judges who regularly adjudicate water issues, state engineers, water policy directors from various states, experts from the USGS, the chair of the Texas Water Development Board, special masters for water. So we created a dialogue among the experts to share their diverse worlds of knowledge with the judges who now deal with these science issues. And Dr. Joe Yelderman, who many of you know, a hydrogeologist at Baylor University, organized other scientists, academics, and graduate students to take the judges on a field trip to have hands-on experience in how local water managers in the watershed develop, manage, tap, preserve, and fight over the area's water resources. We looked at local water systems, watersheds, discussed science of water, land use, and endangered species. The participants saw farming operations relying on domestic wells, the confluence of groundwater and surface waters, and water treatment plants, and most importantly, Salado barbecue. So the dialogue with the scientists and various experts was particularly helpful for both the judges and the scientists, and I look forward to our next panel talking about understanding the science, because that's exactly what we were trying to do at this conference, and we have the legal mechanism now to do just that. Just as we were able to make great breakthroughs in the courts with the use of DNA in criminal investigations, I suggest to you that we are on the verge of doing the very same thing with water issues. It seems as though we've had DNA forever, but DNA investigations have been relatively new, and some of you may be familiar with the Morton Case out of Williamson County, in which DNA was not available at the time of the commission of a murder in Williamson County of Mr. Morton's wife, but it became available during the course of the case. And 25 years after he goes to jail for the murder of his wife, DNA is used to exonerate him and to find the actual murderer who has been released and who, in the meantime, has murdered another person. So this is a wonderful example of the use of science in our courts. So the Morton case coincided with the United States Supreme Court case in Daubert versus Merrill Dow Pharmaceuticals, a federal case, which provides a guideline for expert evidence admissibility at trial. This is the responsibility of a judge in a trial proceeding involving any expert and certainly scientific evidence. It requires the trial judge to make a preliminary assessment of whether an expert's scientific testimony is based on reasoning and methodology that is scientifically valid and can be properly applied to the facts at issue. The case established a guideline for expert admissibility in federal cases, but many states, including Texas, have adopted the Daubert standard. While the Daubert case involved medical device litigation, the standard has been invoked widely by judges in cases utilizing all expert and scientific evidence. Daubert established the factors to be considered by a trial court when it evaluates the admission of expert testimony. Although some trials deteriorate into a so-called battle of the experts, when used wisely by lawyers and admitted as evidence by competent judges utilizing the correct criteria, it can raise the level of the scientific evidence invoked by the parties at trial and made the basis of decisions by fact finders, usually juries. For the evidence to be admissible before the jury, the judge hears the evidence out of the hearing of the jury and evaluates the qualifications of the expert. I think some of you have probably participated in those hearings. And the expert gives his opinion on the subject at issue, and then the evidence is determined by the judge to be reliable and relevant if the expert is found to be qualified. So the judge thus acts as a gatekeeper to the admissibility of the evidence to be presented to the trial. So we have an example of the rule of evidence that we can put up on the board. Okay. So this is the Texas Rule of Evidence 702, which is very similar to the federal rule as well. And you see that it says that a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact, that is the jury, generally the jury, to understand the evidence or to determine a fact in issue. So the judge determines if the expert is qualified, if the testimony is reliable, and if it is relevant to the dispute at issue. As a result of this rule and Daubert and subsequent cases, courts have stepped up to science in the courtrooms. In criminal cases in particular, I think it's led to an increased use of science in investigations as well as in the courtroom. As with fingerprint, DNA, arson, other evidence, it has become more common to hold investigations and thus convictions to a higher standard. So when I was a prosecutor, a federal prosecutor in New York City, we very often used expert evidence involving arson or fingerprints or handwriting. Those standards have changed markedly since that time, and the standards have become much higher. So this is where the challenge is involved in water issues. It can either be a so-called battle of highly paid experts, or it can be a search for the truth. And that is the challenge of the legal system and the call to good and competent judges and ethical and knowledgeable lawyers, experts, academics, and scientists. So I look upon Rule 702 and the Daubert line of cases as a high calling to all of us, those who make policy and laws and those who provide data and facts. It's an opportunity to provide the best science to our system. So then finally, I want to leave you with some thoughts and a final point about water, to invoke that oft-used phrase that I think works well in this context: all water matters. Water is a complex question, and there are many questions that we will be exploring over the next couple of days. And I just raise a couple of these issues with you. We'll be talking, I'm sure, about groundwater conservation districts. Are they an adequate response to a statewide problem? Should there be a statewide agency who also addresses these problems? Our groundwater is of great concern. Our supplies are being drawn down. Should groundwater production be regulated for the entire state? Are we able to coordinate the good work of the groundwater districts, which are spread throughout the state? Should flood insurance be reformed? How does flood insurance inform rebuilding and planning after the hurricane? Are there places where building should not occur? We'll be addressing the New Mexico-Texas Pact that has recently been addressed by the United States Supreme Court. And then a couple of very important final questions. How clean is Texas's water? How effectively is Texas enforcing its water pollution provisions? And a separate question, how toxic is Texas's water? Is there chemical runoff into rivers and the Gulf of Mexico? We all like to think that what happened in Flint, Michigan will never happen here, but Texas is not exempt from the toxicity problems that plague Flint, Michigan, where over 20 people have been indicted with charges that include involuntary manslaughter, obstruction of justice, misconduct in office, and other charges. Even accusations of falsification of blood level data in Flint children. What is more fundamental than water treatment plants and their monitoring? And questions involving reuse, I'm sure, will be raised, but the most difficult question at all, at the risk of raising more questions than we can answer, but to challenge us, I will leave you with a final thought. Should we take public rights in water more seriously? Ed McCarthy raised with you the 1917 Texas Constitution clause called the Texas Constitution Conservation Amendment, which provides for the conservation and development of all natural resources of the state. So we have in our 1917 Constitution the mandate that the public interest is taken into account. The Constitution is clear. It establishes state water policy. It also provides for the legislature to pass all laws as may be appropriate thereto. And along with that is the importance of the public trust doctrine, which I hope we will discuss at great length, which some academics believe has been put into our Texas Constitution in the form of the Texas Conservation Amendment. So I've gone on a bit here, and we have so many other things to cover, but I want to raise with you that we can learn from each other and from other states and even other countries. So the science of today is the technology of tomorrow. It is of great consequence, and all water matters. Thank you.
Thank you. Can you hand me the clicker?
Yes.
Yeah. Justice Patterson, now you know why she's the academic among us. She's the actual scholar on that. Okay, Rule 702. How many here are not lawyers in the room? How many here have watched My Cousin Vinny, the movie? Okay. You remember the scene where his girlfriend's up on the stand talking about whether this Pontiac had Positrack and all, and the prosecutor said, "I object. She's not qualified." And so then he said, "Okay, go and tell me your background." She had been rebuilding cars with her dad all her life, and the judge says, "Well, she's qualified." Well, that's all this fancy language up here is. When you put an expert up there, you've got to show either by their knowledge or their skill or their experience they're an expert. And if you do that, then the court lets them come in as opinion. So that's 702. But I wanted to go, since we're at an economic forum, well, let's see, where are we? I'm going backwards because I'm holding it upside down. Okay. So this is to an acknowledgement of Professor Griffin. The difference between scarcity and shortage. Scarcity, in a hypothetical world in which every resource, water, hand soap, expert translations of Hittite, inscriptions, enriched uranium, organic bok choy, time, was abundant, economists would have nothing to study, right? There would be no need to make decisions about how to allocate resources and no trade-offs to explore and quantify. In the real world, on the other hand, everything costs something. In other words, every resource to some degree is scarce. Now, what's shortage? And if you go look in the Webster's dictionary, they'll say scarcity and shortage are synonyms. In the economist world, they are not. Shortage. In everyday life, people use the word shortage to describe any situation in which a group of people cannot buy what they need. For example, a lack of affordable homes is often called a housing shortage. In economic terms, however, this is not considered a shortage. In any market economy, there will always be people who cannot afford certain products. The term economic shortage means something more specific. It is a situation in which people who want to buy a product at its current price cannot satisfy that desire. In other words, a shortage results from an imbalance between demand, how much of a product or service consumers want, to and are able to buy, and supply, how much of that product or service is actually available for purchase. Now, when Hurricane Harvey hit, and in Houston you had to shut down gas stations, and then the refineries got shut down. But how many had found a hard time finding gas in supply in College Station, or Bryan, or in Austin, or in Dallas? If you talked to the jobber there, it was not the result of the refineries shut down after the first week or so. It's because they were not raising their prices. They'd committed to keep their price at the same for their gallon of gas during this tragic time. And as a result, even though they got the same supply of gasoline, it was gone in 2 days because everybody was scared they needed to fill up their tank. And then the next supply of gasoline, which was scheduled for the following week, would not come. Eventually, the things settled down, and people began to realize they didn't go and immediately gas up. But that's an example of shortage, which was a function of, at the current price, there was not enough for everybody to buy, but the demand was high and the supply was low. And so in the economic terms, if the price had floated up, people would have made a different decision about when to buy their gas, and potentially the supply would not have run short. So I wanted to give that as the background as we go on now and we talk about the water cases. How many are familiar with the Elephant Butte Dam? Okay, some of you from West Texas are probably familiar with that. My Chief Justice, Tom Phillips, when I was on the court, always was fond of saying if Texans hadn't been such bad negotiators, we would have had the western boundary all the way up into northern Colorado because we would have had the Rio Grande for our state only. Well, we were bad negotiators, and as a result, we have to share that water. And I'll call on Justice Blacklock, who knows all about the current battle that's going on over there, and I'll try and keep him up with that. But go ahead. You want me to get you to the
No, that's all right. Thank you, Justice Enoch, and thank you to Texas A&M and everyone here for being here, and for the staff who helped put this on, for making it all happen. I really appreciate the invitation, and pleased to be here today. So yeah, we're going to talk about Elephant Butte Dam. The topic we were given for this panel is understanding the legal complexities of water law. So I think it's appropriate that we would spend some time talking about the only lawsuit that I can think of from my many years at the Attorney General's office where the case was so complicated that the office had to go hire outside specialty counsel. Even though we've got several hundred good lawyers at the AG's office, we needed special lawyers who specialize in this kind of thing to help us with this case. It's the only case I can think of where we had to do that. It's a lawsuit between the states of Texas and New Mexico over rights to the Rio Grande River. And because it's a lawsuit between two states, it's very unique. There's original jurisdiction in the United States Supreme Court, which means that you don't start off in a trial court with the normal kind of situation with a jury and all that you would think of, and then progress to the Supreme Court. You start in the Supreme Court in a case like this, and the Supreme Court hires a special master who's a water law expert to help it adjudicate a case like this. It's a contract case, really, at heart. It's about a compact between the states of Colorado, Texas, and New Mexico about how to allocate the water in the Rio Grande River. But it gets much, much more complicated than a regular contract case very quickly because the case is about hydrology, really. The case ends up being about how groundwater percolates in southern New Mexico below this Elephant Butte Dam. How does the groundwater percolate into the river, and how does the pumping of groundwater, primarily for agriculture in southern New Mexico, how does that affect how much water gets to Texas in the Rio Grande River? And those are very, very complicated hydrological questions. And when you have, just demonstrates the complexity of all this, because very few lawyers are really qualified to handle a case like that. Most judges would have difficulty with it. You have specialty lawyers and a specialty judge handling this case, trying to figure it out. This all started in 2013, and it's now 2018, and the United States Supreme Court, where the case is, has just made a pretrial ruling, a preliminary ruling in the case. We're 5 years in. So that, again, demonstrates the complexity of it. And this idea of the case starting in the U.S. Supreme Court is very interesting to me as a lawyer. It's very unusual. And as I was looking into it, I came across a quote that I really want to share with you. This is the U.S. Supreme Court just a few years ago describing the reason why cases between two states start in the United States Supreme Court. Often these are water law cases. But the court said, "This court's role in these cases is to serve as a substitute for the diplomatic settlement of controversies between sovereigns and as a substitute for the possible resort to force," which, of course, conjures in your mind images of the armed forces of Texas and the armed forces of New Mexico gathering at the state line. And we laugh, and we're fortunate that that's not actually on the table in our peaceful internal affairs in this country. But this is water law. This is groundwater law. This is the livelihood of farmers and ranchers in that part of the world, and it does raise a lot of big passions. And fortunately, I don't think there will be a resort to force, but it's a very, very serious issue for the people in southern New Mexico and for the people in Texas, primarily in the El Paso area, which is growing in leaps and bounds and needs more and more water all the time. So there's the Elephant Butte Dam. It's near Truth or Consequences, New Mexico, which is such a strange name. Traditionalists still call it Hot Springs, New Mexico, which it was called until the 1950s, when the town literally changed its name so that it could host an episode of the 1950s game show called Truth or Consequences. That is a true story. And there's a lot of agriculture in that part of New Mexico, particularly the growth of hatch green chilies is very dependent upon the groundwater in southern New Mexico. And so depending on your culinary tastes, even if you're a Texan, you may actually be hoping that New Mexico does well in the case. So getting to the substance, Texas, Colorado, and New Mexico have a contract about how to allocate the water that flows through the Rio Grande River. And it's a complicated agreement that I can't do justice to in this setting, but the basic idea is that a certain amount of water is supposed to flow from Colorado to New Mexico, and then another amount of water is supposed to flow from New Mexico to Texas. And when it rains and when there's water flowing in the river, the levels that are guaranteed to flow are never an issue. The compact only becomes an issue when there's a drought. And the compact is administered by the Rio Grande Compact commissioners. Each state in the compact has a commissioner. Our commissioner in Texas is appointed by the governor. And the slide shows some historical detail on the background of how all this came to be. The dispute basically originated because drought conditions resulted in increased groundwater pumping in southern New Mexico, which, because of the drought, significantly decreased the amount of water that was flowing down towards El Paso. And that led to an agreement between Southern New Mexico Water District and an El Paso Water District, where they got together and they said, look, New Mexico has these obligations. We need to let more water come into Texas, and so we're going to put some restrictions, or at least start down the pathway of putting some restrictions on how much groundwater can be pumped in southern New Mexico. And as you can imagine, that caused a big political dust-up in New Mexico. And what happened was the Attorney General of the state sued the water district. So the state Attorney General sued one of the state's water districts over this decision to allow more water to come to Texas. And the New Mexico Attorney General eventually forced the water district to take a very hard line and to allow the groundwater pumping, which left Texas with less water than it thought it was entitled to under the compact, which is a 80-year-old agreement. So Texas sued in the United States Supreme Court and alleged that New Mexico violated the compact by allowing diversions both of surface water but primarily of groundwater that's hydrologically connected to the Rio Grande. And the pumping was taking place, so water flows into this reservoir, the Elephant Butte Reservoir, and that's the place at which they measure how much water is reaching Texas. But that's a little bit funny because the reservoir is 80 miles north of the border. And so that much water is not actually reaching Texas. So they were measuring enough water in the reservoir for Texas, but then what was happening was that as that water was being released downstream, all the groundwater pumping that was going on south of the reservoir was leading to a situation where, there was a lot of water being released from the reservoir, but not a lot of water reaching Texas because so much water that would normally percolate into the river one way or another was not getting to Texas. So New Mexico says, well, look, our obligation under this agreement is just to get the water to the Elephant Butte Reservoir, and it's not our problem what happens after that. Texas's response is no, even though the compact talks about how much water gets into the reservoir, this whole agreement, this agreement that involves the federal government and these 3 states that was entered to all these years ago, it's all premised on the existence of other contracts and other expectations that guarantee that a certain amount of water will actually flow to Texas and be able to be used in Texas. And you've got those competing views of the way that this compact is supposed to work, and then all kinds of, as I said, very, very complicated scientific questions about, well, how is that water actually getting from the groundwater reservoirs to the river, and how much is the pumping of groundwater in New Mexico actually affecting the flow of the river into Texas? And those are complicated questions that will be litigated as this case continues. So far, as a preliminary matter, the case has gone pretty well for Texas. The special master who's in charge of the case has agreed to this point with Texas's interpretation of the compact. That the compact actually does require a certain amount of water to flow to Texas, as opposed to just flow into the Elephant Butte Reservoir, which is 80 miles into New Mexico. The special master, just again to demonstrate the complexity of this case, his opinion explaining his thinking on what the compact means and on the history of all this, it's 300 pages long, and it's just a magisterial tome about the history of this region of the country and about the way that water was allocated and dealt with over decades and decades and even over a century. It's a fascinating. I did not read the whole thing, I have to confess. But if you're interested in this case, this issue in water policy and water law in West Texas and southern New Mexico, I recommend getting a hold of the report of the special master in this lawsuit, because it's an extraordinarily learned and informative read. Another interesting note about the case, which just occurred, the United States Supreme Court just heard argument in January and decided just in March, just about a month ago, there was a ruling from the United States Supreme Court in this case, and they were looking at just a narrow issue of whether the United States, the U.S. Department of Justice, could intervene in this case and become a party in the case. And the United States wanted to do that to take the side of Texas. And the United States Supreme Court ruled that the United States can intervene in the case and express its view about how this compact is supposed to work. And one of the primary justifications for allowing the United States to intervene in the case was that our country has a treaty obligation with Mexico to deliver 60,000 acre-feet of Rio Grande water, and I'm not sure whether that's annually or how that's measured, but there's a discrete obligation that the United States has to Mexico to allow a certain amount of water to flow into the Rio Grande River where it borders Mexico, which just reminds us, as we're talking about this river and that whole part of the country, that Texas is not the only one interested in how much water is in the Rio Grande River. It's just as much Mexico's interest as it is ours. And so what you have is a very, very complicated issue of policy in terms of how this river should be managed and how the groundwater pumping affects it, and how do we weigh people's property rights against the need to have enough water in the river for everybody downstream. That's impacted by contracts between the states, which are many decades old, but which are binding agreements that have to be followed. So you can't just do anything you want with this water, because you've got these agreements. And then on top of that, you've also got international agreements, not just interstate agreements. You have international treaties about this river that are going to end up impacting the use of groundwater in New Mexico and the availability of water in the Rio Grande River for the people of El Paso and for agriculture in the El Paso area. So the status of the case is that it's been remanded to the special master, which means it's been sent back from the Supreme Court, which just looked at it, to the special master, who so far has made some rulings that are good for Texas, but the case has a long, long way to go, even though it's already 5 years in. And Your guess is as good as mine on where it will end up. But it's a very interesting lawsuit, and I think aptly demonstrates just some of the complexity of water law.
Thank you, Justice Blacklock. I wanted to, the U.S. Constitution, one of the things when it was founded is what would be the rights of the states. And so the states cannot have contracts among themselves to deal with cross-border governance. So it requires the federal government, Congress, to approve the treaty between the states. That's what becomes a compact. So I was a little bit surprised the Supreme Court was looking outside of the United States for a foreign treaty to decide whether the solicitor could get involved, because clearly if Congress approved the agreements between Colorado and New Mexico and Texas, if Congress approved that, I would think that the Solicitor General of the United States would have had an interest in what Congress thought it was agreeing to do. I wanted to go back, look at the date, 1985. With plentiful rain, Colorado cleared its debt to New Mexico. Apparently, as the reservoirs are being built, the water can be collected by the state till its reservoir is full. Then it starts passing the water through, and the amount of water it retained is considered its debt. And when it gets full, then it passes it through until its debt is satisfied to the downstream state, New Mexico. So in 85, with plentiful rain, I say plentiful rain, but actually the headwaters are up in the Rocky Mountains, and a lot of snow melts, feeds the Rio Grande River, and it comes down through that way. Colorado cleared its debt. How did Colorado clear its debt? It cleared its debt because New Mexico filled up its reservoir. So the water passed through out of Colorado down into Mexico. New Mexico filled up its reservoir at the Butte Dam. And so Colorado's debt disappeared. And New Mexico said, wait a minute, we don't want to do that. So after 1985, New Mexico just never filled up the Butte Dam anymore and passed the water through. And so that way Colorado could never clear its debt if its reservoir needed to be filled, and it decided to fill its reservoir. As we identified, with the drought of 2003, the Rio Grande turned down to just a little trickle. It's coming through Texas. In 2003, they closed the dam off at Butte, which it didn't have the water flowing through, and that's when the farmers started pulling 80% out of the groundwater. That's where this issue was eventually coming from, because the water just was no longer flowing, but the reservoir was never full in New Mexico. So that's kind of where this issue starts percolating along. Now, there was an answer to all this problem before those states were created. This is John Wesley Powell. In 1883, at an irrigation conference, he suggested that the states out west not have geographic boundaries, but have boundaries based on their watersheds. They didn't do it. He said, gentlemen, you are piling up a heritage of conflict and litigation over water rights, for there is not sufficient water to supply the land. Powell's recommendations for development of the West were ignored until after the Dust Bowl of the 1930s. This is what he designed. New Mexico is blue and green. You've got Arizona down there. You kind of measure the New Mexico boundary, but everything else is based on watersheds, where water would be collected and where water would run. And I was trying to figure out those lines. Those lines are not rivers. The boundaries are not rivers. My guess is it's the high point in the land, where then the water flows into the watershed. Now, John Levy came along later, and he said, what a wonderful idea. I wonder what the United States would look like if the entire country was divided up by watersheds. And so he's divided all this up, and it's great, except I think Texas would disagree with Oklahoma being bigger. So, obviously it's not surprising. It was never identified. So we talked about East. 1904 was East, when water was considered mysterious and occult. Water flowing under the ground. We had no idea what was down there. This was before oil became the big thing it was. So in 1904, Houston and Texas versus East, this was back when railroads won their lawsuits in the Texas Supreme Court. The choice between rule of capture and reasonable use was being raised. Now, what's the difference? Who owned this mysterious and occultish water that's under their ground? Was it the person who owned the surface estate, or was it the person who pumped it out? And the Supreme Court said, well, we're going to follow a British case, 1843, that set the tone for rule of capture. So whoever owns a surface may dig and take as much as they want, but until they do, they don't own the water. So they have the right to go bring up the water, but it's not theirs until they've actually captured it. And that rule of capture we discussed earlier became the rule for oil and gas. So there's one similarity. Cipriano comes along later, many years later, 1999, and we've been asked to reconsider this. And I thought the reason I got invited is so people could criticize me about the opinion here, but I'm not going to give you that opportunity. Should court reconsider East? Well, we looked at a 1955 case. We've already identified Corpus Christi versus Pleasanton. They identified 1955 that maybe the flow of water really wasn't a secret and occult body, and it's not anymore. And we've talked about science in the courtroom and what engineers have discovered. We now know a lot about hydrology and where water goes. We also identified in that case that there was rule of capture has exceptions. You can't willfully or wantonly just throw away water just because you can on your land, recognizing that people downstream of this groundwater had some need for that water, so you couldn't do it. In 1997, we talked about the rewrite of the Texas Water Code, a very significant rewrite of it, where they created water districts and a regulatory scheme for kind of managing the use of water. But the statute was silent about whether Texas was beginning with the premise that it was rule of capture or reasonable use. I'm not sure if you look at cases that deal with reasonable use, they often define reasonable use as not wasting or throwing away water. So I'm not sure, as we move forward, there's a significant difference there. But in Texas, the rule of capture remains. The significant in that is it says, for now, we recognize that rule of capture was a court-created thing. We recognize that changes have occurred, but we wanted the 1997 statute to play out. Let's see how water districts do. And that's kind of where things have gone so far. After Cipriano, the Supreme Court got guitar holding versus Hudspeth. I wanted to find a nice picture of a guitar, but I couldn't figure that out. Oh, I should tell you. Ozarka Water. The problem here is Cipriano was losing their water to Ozarka, who was pumping like mad out of a common water source out there. And, I mean, I hate to disappoint you. If you don't like the taste of water where you live and you buy Ozarka water, you're just tasting where the water is in East Texas. That's about what it amounts to. But they've priced it. A good economist would say they're pricing water for what people are willing to pay for, right? Next case that comes along, well, first of all, guitar holding. Water districts were starting to permit the use of water. Guitar Holdings was a ranch. They pulled water out to feed their livestock, but it's kind of a deserty area, so they just pulled it out to feed their livestock. A neighbor sold his water interest to one of those, pump out the water and put it in a bottle and sell it on the commercial market, right? And they were pumping thousands and thousands and thousands of gallons a day. So the water district, Hudspeth County, comes in and says, okay, we're going to decide historical use on water as we now establish permits to regulate the use of water. And oh, by the way, your permit will be based on historical use. So the Guitar family, who has a whole bunch of water under their ranch land, gets stuck with a permit for a few hundred gallons a day. And the neighbor, who just sold his rights, and actually the now owner of that rights, who's been pumping thousands and thousands of gallons of water, they get a permit to pump thousands and thousands of gallons of water, and Guitar gets a permit for 100 gallons, let's say. Use that as an example. I don't remember exact the numbers, but it's significantly different. And the Supreme Court said, the water district, the historical use is not limited to permitted use. You look at the nature of the use and what it is and make your permits reflect what the nature of the use will be. And so they sent it back for the district to reconsider how they would issue permits. Edwards Aquifer versus Day comes along What does ownership mean? Can there be a taking? And when I refer to taking, the Fifth Amendment says that the government can't take your property without paying you for it, right? There's a lot of exceptions to that, a lot of differences, a lot of arguments. There's lots of case law about it. But basically, the Edwards Aquifer versus Day was claiming by the way they were permitting water out of the Edwards Aquifer, they were effectively depriving me of my use of the water under my property. And so they were claiming this was a property interest, and the government, by their permitting, was taking it. And that was the question that was being decided in Day. In Day, it also discusses oil and gas similarities. Oil and gas flows under the water. There's not a barricade to oil except natural geologic formations, but it flows. Maybe not very fast, but it flows. A lot like water flows underground. Sometimes it's in the aquifer, which is a big underground river. Sometimes it flows through the sand and the rock, just like oil does. But it remanded to the trial court to consider the constitutional claim. It dismissed everything else, but said, can there be some taking here? One of the things that I think is the in between the lines in Edwards Aquifer versus Day, remember the right of capture? I know it's under my land, and it means something, but it's really mine. I have the right to dig all of that up and keep it or sell it, but it really becomes mine when I've pulled it out of the ground. Now it's mine. I can actually hold it, and I can sell it and do something with it. But it never really decided the question, if I didn't do that, did I still have some property interest underground? And they really decided that question. It's not a real capture case per se, but it is saying that there is some private property interest an owner has in the water under their ground, even if they don't pump and try and capture it. We've already mentioned Coyote Lake versus Lubbock. I thought this was cute. It is Coyote Lake, but the real issue was the ranching that was on the property. Way back in one of the droughts that was going on, Lubbock needed a lot of water, and Lubbock got a deed for water rights and then claimed under that deed that it had the right to drill wherever and whenever it wished on Coyote Lake private property. So they came together and they said, well, Lubbock's growing. We need more water. So they dug 60 wells, all within a very compact area, obviously where the water was. And they mowed the grazing grass through huge swaths of the surface land. As I said, this was a ranching operation. It's deserty. It's fragile grasses that were being used as feed grass for the cattle ranching operation. A lawsuit. Coyote Lake suing Lubbock. You can't just destroy our surface just because you have the right for water. Well, the deeds were silent about this. They didn't say anything. So the court has an extensive discussion about surface rights under oil and gas. It's called the accommodation doctrine. I might sell somebody else the minerals or lease the minerals under my property to an oil and gas operation. And the operator comes in and starts drilling the well. Well, early on, because they say we've got the right to drill, surface owner, you can't prevent us from going after the oil that you just leased to us or gas by claiming, well, you can't do it on my property. And so this whole law came into existence. Well, no, the oil company can come right on your property and drill a well, but they have to make a reasonable accommodation for your surface rights. They can't drill the well in your living room. They can't drill the well in the middle of your driveway. They can't drill the well right through your water well. They have to make a reasonable accommodation to you, and many times you have oil companies come in and they just replace whole buildings because this is where they have to drill, and they just go to the surface owner and get permission, and they build the surface owner's building someplace else. That's called accommodation. And so the decision was, unless the agreement has expressed terms, the accommodation doctrine will apply in water recovery. So that's a new movement. Again, the Supreme Court is talking about oil and gas principles and incorporating in the use of water and water rights. What I wanted to get us to was Mark McPherson's paper. He's a Dallas attorney. He did a CLE just recently in 2017. and he wants to look at the post-Coyote Lake case. He wants to see what's happening in water rights. And he says this: courts seem to be using broad language indicating an intent to apply the entirety of oil and gas law to groundwater estates. But he raises several questions. First of all, he identifies the similarities. Water and oil and gas, they flow subterranean, right? The interest can be severed. We saw that. Coyote Lake severed their water interest and gave it to Lubbock. Dominant servant estate, not so sure. That's a bit of a similarity. But in water, until Day came along, it wasn't quite sure that there was actually an ownership interest in the groundwater. And the whole discussion about accommodation was the result of the oil interest, the minerals, dominating over the surface estate, which had not ever been decided in water law. But with the adoption of accommodation, we're thinking maybe now the dominant estate is the water interest, and the surface estate now is subservient, must allow drilling for water that they go. We know that rule of capture, it's the same thing in oil. You have an interest with oil in the ground, but you really own it when you bring it to the surface, and now it's yours. And again, we have, absent an express agreement, which you could do in oil and gas, you have the accommodation doctrine that applies. What are the dissimilarities? Oil and gas, Mark suggests it has one use. Well, we can think of subsets of that use: fuel, heating, fire, but basically it's a fossil fuel. It's used to create energy. That's what you use it for. Water has multiple uses. You pump water to fill your swimming pool. For recreation. You pump water to feed the cattle. You pump water for personal drinking. We wouldn't do that with oil and gas. We do it with water. Well, depending on where you live and the minerals in the water. But water has a number of uses and beneficial uses, and we've talked about public uses for water. There's public swimming pools, public fountains, but generally for the welfare of your community, you have to have an ample supply of fresh, drinkable water. An economic market. Both water and oil and gas have an economic market, and I say that advisedly. You go to the grocery store today and you buy bottled water. And in one of the cases, I think it was Day, it may have been the Day case. No, it was Cipriano. I think Justice Heck wrote a concurring opinion noting that a 8-ounce bottle of water cost more than 8 ounces of crude oil. So there is a market for water being sold. Waste. A dissimilarity here is a term of art. In the oil and gas context, the operator has a duty to the royalty owners to pump as much oil and gas as they can. They got to get it out of the ground. And what governs it is reasonable market conditions. But the premise is that it's a usable, needed resource. Somebody's giving you the right to pump, and you go pump, and you pump as much as you can, subject to reasonable market conditions. Water? Do we really want to pump as much water out of the groundwater as we possibly can? Well, there's another angle, conservation. We want to, while they talk about conserving natural gas, truly, conservation has an entirely different meaning for people needing to have fresh water to survive, right? So there's a difference in waste. Transportation. Water historically has been transported. The Butte Dam transports the water down the Rio Grande River into Texas. Colorado, after it gets past its dam, transports the water down the river course. So it's an open access. You just don't build a lot of pipelines, at least in the natural water event, to transport it. But oil and gas is always transported in a pipeline. There's always a control over the seller who pumps it in one end and the buyer who buys it out of the other end. But there's transportation. The other deal is the political will. That's a dissimilarity. Back in 1917, I guess, when the first oil and gas issues came along, very few people really knew oil and gas. There were always investors invested in oil and gas, and they had an interest in how you do that. The state got involved in regulating it, And so it moved along an entirely different path than water. Today, you have issues, state interests, you have local interests, and you have private property right interests in water. You've had all of that in oil and gas, but for 80 years, well, 100 years, people have gotten used to how you regulate the resource of oil and gas. The regulation of water came a little bit later. Here are the questions for us to discuss. Talking about waste. Does not waste, it's an affirmative duty to produce, run counter to the duty to conserve? I've already suggested that it does run counter to the duty to conserve, which makes water significantly different than oil and gas. Practically speaking, can there be a property interest in groundwater without a surface right? Well, we don't have a history of leases for water. The Coyote Lake and city of Lubbock, they did it by a deed. I'm going to deed you my groundwater. And they did it like that. They didn't do a lease. So the property owner didn't retain some sort of lease rights. But practically speaking, if I've got an ownership interest in the water, don't I have a commensurate ownership interest to dig and pull out as much as I can, the rule of capture for a water interest? So can you really divide water under a rule of capture concept from the ownership of the surface estate? Should groundwater be subjected to pooling? Those of you involved in oil and gas, you know that there are several pieces of private property with surface that have the same oil field down there. And so the Railroad Commission pools. So you can have your interest pooled with everybody else's interest, and then as the landowner, if you've retained a royalty interest overriding, you get a portion of all the oil pulled out of the pool that your neighbors are also having their oil pulled out of. Would Day, as an example, be willing to have their water interest pooled with a neighbor who has their property over the Edwards Aquifer? That's another question. Who creates correlative rights? I don't even know what correlative rights are. It has something to do with I have as much interest in that pool of oil under my ground as you have in the pool of oil under your ground because it's the same pool. And so the government came along, and I've talked about pooling, but all of this has been done by regulatory measures, by statutes on kind of affecting personal property rights in what's under their property. It'll be government that has to create the correlative rights with water. People who live over the Ogallala Reservoir or over the Edwards Aquifer Reservoir, government's going to have to do that. Maybe that's the water districts that do that. Maybe that was their attempt to do so. Can there be an effective water policy without state-centered regulation? And I thought that's I want to present that. We have people here with water districts. We have attorneys here. We have people from state agencies that are here. What things, does this cover the waterfront of the questions? Or do you see other questions, just from your personal experience, that really affect how can we have a water policy? I'll leave you with this one thought. The executive director of the Lower Colorado River Authority, LCRA, will get up here and tell you we have plenty of water. It's just not where we need it. Boone Pickens tried to capture water rights all over northwest Texas with the idea he'd sell it into the cities that needed the water. And he got stopped. Legislature stopped it. Cities that need water are routinely looking for ways that they can arrange transportation. Remember, transportation historically has been through rivers. Well, now cities are talking about, well, let's build a pipeline up to some reservoir, and we'll pipe the water from there. It's, I think in 250 miles, San Marcos could have a pipeline to the Sabine Reservoir, right, which is shared with Louisiana, by the way. So they could pump it up there and pump it down. But then they got to cross private property to build a water pipeline. Governments don't seem to want to do business with private investors. So there's lots of money to build pipelines to bring water, but the government entities on either side don't want to deal with private investors. And many of those pipelines will cross water districts. They'll move from one water district to another. One of the water reservoirs in Texas has 2 water districts governing it. I can go to one water district and buy plenty of water from them and pump it out of exactly the same reservoir that the water district that's much closer to where the water is needed says, wait a minute, we need it for our own growth. We're not going to let you pump it out of the reservoir. Just issues about water policy. And I've been doing all the talking, but Justice Patterson gave you a lot of interest about the background. She suggested there is an interest in public need for the water. Do you want to elaborate on that a little bit?
I think at this point, to stay on schedule, we need to stop, but we're going to shortly be on a break.
I'm sure it will
They've
come
got a
up.
stop sign on us right there.
Yeah.
We don't want to run through it.
But it
I
is
had
the
my
public,
clock off. I
it
thought
is
I
the
had 10
public trust
Well,
doctrine.
never mind.
It is the public
Where's
trust
that bell?
doctrine.
Where's that bell? You're saved by the bell. There you go.
And we
Thank you,
can't
Greg.
live without water. I have to add that.
Thank you very much.
Okay.